Well, congratulations. You've made it to the end. The only thing standing between you and graduation is me and the other 5 professors that follow. So let's figure out how you're going to get to the end and be happy come June. You've got an excellent set of books. You need to work them over the period of the next 3 months and work them hard. You should start each section having gone through that outline of material that's in the book that goes over it very carefully. These explanations are as good with respect to the analysis of the questions and not just why the right answer is right, but why those other ones that are often way too close to be able to make an easy analysis and come up with the right answer relatively quickly, why those ones are wrong. And so what you want to do is really work the material. You need to go over your outline before you start each section of the course and really start to think about the black letter law to a much greater extent than you probably presently know it. The way in which to pass this course, especially evidence, but I think all of the sections are like this, is you must have a better understanding of black letter law. The evidence section rewards the rote memorization of black letter law to a much greater extent than you probably presently possess that understanding. And then what we do is once we have that black letter law down, we apply the law mechanically. And what that means is step by step by step. You don't jump, for instance, to a hearsay exception until you've done your full hearsay analysis under 801. There's no reason to look for an exception to the rule if the rule itself doesn't apply. If you think it's a best evidence problem, then you must take the definition of best evidence and make sure that it is piece by piece by piece a best evidence problem, and then figure out then whether you need to produce the original or you can adequately explain the loss of the original or there's some other exception to the rule that applies. Evidence and every other subject means that we've got to step up our knowledge of black letter law. With respect to the multiple choice questions that form the basis of the course, the core part of the course, you should be doing them by process of elimination. You should be looking at those 4 answers and eliminating the bad choices. You don't just jump to what you think. Your gut or something else tells you that must be the right answer. You look to exclude the wrong answers. On a multiple choice test where there are 4 answers, a monkey starts with a chance of 1 out of 4. Every time you can eliminate a bad choice on those 4 answers, you improve statistically your odds of passing the test. So if you can eliminate 2 answers simply because either they are a misstatement of the law, and a misstatement of the law can never be the correct answer on the bar exam, right? If it says something that the law, and you know the law isn't, that's the wrong answer. You scratch it out. You're down to 1 out of 3. For whatever reason, you can eliminate another one. You're down to 1 out of 2. You do not have to do significantly better than 1 out of 2 to pass this test. You have 200 multiple choice questions. For most states, including ours, you need a score of 135 out of those 200 to pass. That usually will include a scale of somewhere between 10 and 20 points. So they will add 10 to 20 points to your raw score in order for you to get the required score of 135 on that part of the test. That means 125 in essence raw out of 200, 62.5%. And so what that means mathematically is you really don't need to do much better than 1 out of 2. But every time we eliminate a choice, we improve our odds statistically of passing the test. There will be questions then that because of a misstatement of the law, because of a rule that doesn't apply to the question. For instance, there's a couple things in evidence that become very, very important for you to know to a much greater extent than you know now. Which is the only hearsay exception which requires the declarant to be available? Past recollection recorded, right? So here's just a small thing to think about with respect to that. If we have past recollection recorded as one of the 4 answers, and there's no showing that the declarant, the person who originally made that statement, is available, then that's the wrong choice. It can't possibly be the right choice. You eliminate the answer. What are the 4 unavailability exceptions? 5 actually, right? 2 Ds and 3 Fs. Dying declaration, declaration against interest, former testimony, family history, forfeiture by flight of a witness. If one of those 5 answers are listed as one of the answers, or lucky, hopefully for you, more than one of the answers, and there's no showing that the declarant, the original speaker, is unavailable, those are the wrong answers. You scratch them off. You're down to 1 out of 2. We're down to 1 out of 2. There's Latin in one of those last 2 answers. For the purposes of evidence, it's wrong. Why? Because no Latin made its way into the FRE, and the FRE is the only thing that's tested on the multiple choice part of the bar exam. There are some things, if you know the law better, you're going to do better on this test, and that's what we're going to try and work on, and that's what you need to work on in the next 2 weeks. As you go through the sections, really work with those books. They're as good a set of materials as you're going to get. They're as comprehensive. And don't just jump to the questions. I think sometimes people think we can jump to the questions, we'll get all the questions, and you can fool yourself because you can get lucky on some of the questions. You can get, a lot of times if you've done any questions yet, you get down to 2 answers. And sometimes that might as well be a flip of the coin to figure out which one you're picking. What you want to do is get the law down to the point when you're down to 1 out of 2, you know why you're picking the right answer. And especially on those, don't just look at, when you go over questions, the ones you got wrong and say, well, I got it right, I don't have to look at that answer. Because a lot of times when you're down to 1 out of 2, it really is a flip of a coin. Make sure you got the right answer for the right reason, so the next time you see it, you make your choice a little easier. Don't just think, because I got it right, I don't have to double check my analysis. Double check everything. We want you to go as much as you want to leave, but you got to meet us halfway, and you got to work with these materials now. We want to get you ready for the most difficult test you're ever going to take in your life. The way to do it is to say, I'm going to bust ass for the next 3 months. I'm going to get ready. I'm going to then bust my ass for the next 2 months. I'm going to take this test once. I'm going to do it right, and I'm going to be done with these bastards forever. Okay? And honest to God, I want that for you, and you want that for you. But there's no easy way around this. Okay? This is a tough course with a tough set of materials and a tough area to work in. Not everyone gets to be a lawyer. So work with me, work with the professors, use those books. They're as good a set of comprehensive materials as you're going to find, and hopefully what you'll find is this will get easier as we go. But you don't want to take a chance with any of these sections, especially this one. This one's a tough one, but this one is one that if you really put hard into it and master this law quickly, that by the time the test comes in really just 2 weeks, that you'll be in much better shape and more confident. This is a section of the test, by the way, evidence that you can get into the range of about 75% correct, but by mastering memorization of the law. And I can't underestimate that. Evidence with respect to the hearsay now, hearsay constitutes about a little less than 5% of the test, of the entire test, not just evidence. It's about a third of the evidence section. If you master hearsay, you've got a significant portion of the test, and it is an area that is easily masterable. But it requires you to memorize the entire definition of 801 first to see what is and isn't hearsay, and then the rest of it actually falls into place. But 801, you have to have all of that down before you can start to think you know hearsay. I've got for you up front here, you don't need to take it now, but I want you to take it before we leave because it's for later. There's a handout on Crawford, and we'll talk about Crawford, obviously, with respect to the Confrontation Clause, the Sixth Amendment, Melendez-Diaz, that line of cases for your analysis in criminal cases, which are important. I've got another handout from the bar examiners here, which is the outline of coverage for all of the tested areas on the bar examination. And so specifically I want you to look at the evidence section, and they tell you not just what topics are covered, but in what denominations, what percentages those areas are likely to be covered on the bar exam, so you can start to think about using your time wisely. With this handout, There is a lecture already posted online that I've gone over, which, with respect to the outline of coverage. You should be able to look at this outline of coverage for the evidence section, and every one of those things, you should be able to write a sentence or two as to what that means. There's a lecture online where I go over what each one of those means. I think that would be important for tomorrow, after Patriots win this afternoon, to go over it and to think about it, and maybe do it more than once. There's also a lecture on what I call the 5-part evidence test, which is online already as well. If you have not listened to that and understand that, then you ought to do that again as well. Because obviously there's 1,000 different numbered rules. But you have to have a framework to be able to start to address some of these problems, not just on the multi-state, but on the essay as well. And I think both of those lectures will advance your knowledge with respect to sort of the survey of the course. We're going to do a couple specific areas this morning, but those are fairly comprehensive that you should have a good understanding of, because while we can do the major handouts that we're going to talk about this morning, and that may be 75% of the material that at the end of the day is tested, they also are going to test the details, right? It's not just the big brush here when we do multiple choice questions. They like to test the details. They like to test the exception to the rule of law. So your knowledge on that rule of law has to step up a little more. Those two lectures should help you give a better breadth to it, as well as the material that you have in the books. So grab one of each of these on the way out, and if you don't have the handouts are here as well. We will have a quiz in every class. Today we will have 2. On Saturdays we have 2. We take your best 3 at the end of the day and we add it to your section score, and from there you hopefully will get enough points to move on and keep moving on. If you are not here for a quiz, if you are ill or whatever, you must make the quiz up prior to the start of the next class. You got anything for me? You have any questions? Yep.
Did you already cover the password for your lectures online?
No, I don't think they're password protected. I made sure yesterday, I asked him specifically to make sure they were posted and available, and he told me they were, and I thought I went online as well.
Yesterday there were a couple of hours where we couldn't get onto any of the MSL stuff.
It may have been during the period in which I was having to make sure they were transferred and available so that I could tell you this morning they were. So they better be. No, I wanted to both those lectures, I made sure, at least what the links I was told that we went to, they were both the ones I just told you were available, because I want them to be available, and I hope you use them. The key, in my opinion, for all of this stuff, all of these sections, is we got to get the law down better. Okay? There's no BS or ifs, ands, or buts about it. Okay? If we want to do better as a law school, if we want to do better as a student taking that test the first time, you cannot have a fuzzy understanding of what the law is. Each multi-state bar examination question is 1 minute and 48 seconds long. That's it. That's to read the question, call on the law, make an analysis, circle something, and move on to the next one. That's no time to be thinking about what the hell hearsay. What did he say hearsay was again? You got to hit it, move it, and keep moving and nail it every time. And there's going to be questions that the law is confusing, the question's confusing. I don't have a friggin' chance on this. Circle C and move on, okay? But there's a lot that if you know the law better and have that confidence, you're going to be able to eliminate 3 choices, you're going to hit the right answer, and you're moving on to the next one. But honestly, having done this for a long time, we got to get up here with respect to the knowledge of the law, so that it comes like this. And if you do, these questions get a lot easier. I'm not saying they're easy, okay? I still look at some, and I look at 2, and those 2 are pretty good ones. And occasionally I grab the wrong one, and I look at it and say, okay, I get it. And I think that's a little tricky and maybe unfair, but it is logically where they were going with it. But that's likely knowing evidence a lot better than you guys. And so what I'm saying is we got to get the law down better. Don't go immediately to questions. Work a combination of it, because when you have the knowledge of the law better, these questions do get easier. They're not easy. They're never going to be. But they will get some of the confusing part of it, and just you look at it and say, damn, I have no clue. That will disappear at least. You'll get closer to the target. So, we good? Anything else? Yeah.
Just Mondays and Wednesdays is a day and a night section. Do you care which one we do?
I don't care.
Didn't think so.
Day or evening, Ted, come whenever you like. I'll be here for both. Anything else? Take out your handout on spousal testimony and let's talk about this, because it's the easiest of the handouts that we go over. Let's start with the easiest thing to be able to work through. Everyone have handouts with them? I've got some more up front if you do not. Spousal testimony. When we talk about spouses, partners to a valid marriage, talking about or testifying with respect to their spouse, either where the spouse is a party or about something the spouse did, it's that one, yeah. This is a relatively easy analysis to be able to do to apply the right law and to get the right answer. With respect to spouses, partners to a valid marriage testifying, there's two things we have to ask ourselves. And it really is about the content, the likely content of the testimony. If we're asking a partner to a valid marriage to testify about a confidential marital communication, the rule is, with respect to confidential marital communications, either can prevent the disclosure of that information forever. But each of those words is vital. It must be confidential. Okay? Children, even of a sufficient age to understand that communication, destroy it. If there are people who could be expected to hear that conversation, and they do, that's not confidential. It's possible, though, even that my wife could come in here, we could talk, she could say, Michael, I need to talk to you, we come over here, we talk quietly, confidentially, that even with other people in the room, it could be, obviously there's less of an expectation, but it could be. But if she comes in here swearing and yelling and screaming at me like she always does, that doesn't count as confidential. Marital. The parties must be married at the time the communication takes place. So obviously pre-marital communications don't count for the purposes of this rule. Post-divorce communications don't count. They must be partners to a valid marriage at the time the communication takes place. Confidential marital, the last part is communication. Under the federal rule, we cover not just oral communications, but we cover writings as well. So we would cover letters and text messages and things along those lines. Confidential marital communications either can prevent the disclosure of that information forever, and by forever then what we mean is even post-divorce, because that's where they like to test this stuff at the margins, right? They're not going to give you one dead on where you look at it, it's really easy. Oh, they were super secret communication during marriage, they're still married, oh, this is easy. Not likely. They're going to test at the margins, so you need to understand what the margins are. Either can prevent the disclosure of that information forever, even post-divorce. Okay? You don't lose the protection. The other thing about confidential marital communication, sometimes we think, well, it's just about family issues. No, it's not. All right, I go home and tell Jeannie, geez, I had to steal 10 grand from the law school so we could pay the mortgage this month. She says, okay, honey, you got to do what you got to do. That's a confidential marital communication. It's about a crime I committed, as long as it's only one partner. If the parties are engaged in joint criminal activity, then that's an exception to the rule. But if one party to that marriage engages in criminal activity, they can disclose it to the other. We encourage partners to a valid marriage to talk to the other about anything, not just family matters. Confidential marital communications. Questions on that part of the rule? If it's not about confidential... Oh, I'm sorry.
I just wanted to know...
You got to speak up so they can hear you back there.
What constitutes a valid marriage? Does it include civil unions as well?
The civil union isn't a marriage. It's got to be a marriage. Right? I mean, I don't know whether at some point they're going to be asking you to deal with this. But a civil union is in place of a marriage. It talks about, for confidential marital communications, it's a marriage. So if in this state, as you can here, and in others now, you can marry whoever you choose to marry, then that's a valid marriage. If it's in place of a marriage, then I would apply the rule that I've just told you. That's a substitute for it. Confidential marital communications requires each of the three. Yep.
You were talking about a joint criminal activity being an exception to
Yep.
the rule.
Bonnie and Clyde.
So if they're working together in criminal activity, then somebody can testify.
We can pierce that communication. Suppose Aaron Hernandez was married to the woman that they now may be trying to grant immunity to force her to testify. If they were married and they had private communications, it appears in that case only he was involved in whatever activity, they can't force her. If, on the other hand, the two of them were co-venturers in this murder, then they could force either one of them, potentially. Actually, that's kind of a tricky analysis, because they would still have a Fifth Amendment right, even though they would lose their privilege. Potentially, if they granted one of them immunity, they could force that one to talk about their private communications, because their private communications would no longer be covered by the confidential marital communication rule, because they were engaged in joint criminal activity. Okay?
Yeah.
Yep.
But in the marriage part, legal separation, does that count?
No, you're married until you are divorced. Okay, that's the rule. Even if they're estranged, you are married until you're divorced. So again, to me, this is a relatively easy rule. Each of those, all you got to do is memorize 3 rules, and then apply the fourth part, which is it applies forever. Confidential marital communications. And confidential becomes important too, part of it, because it's not family protection. We have a statutory protection for children who are dependent upon their parents and live in the same household, but I wouldn't worry about that now. For the purposes of this rule and the MBE, it is a marital privilege, but that's not a family privilege. And confident marital means you're married until you're divorced, till there's an actual divorce. Yep?
You mentioned Crawford earlier, and I assume you're going to get into it, but that includes even a threat directed at a spouse?
No, well, in Mass, we have, as a general matter, the answer is yes. Okay? In Mass, we have separate rules for your essays with respect to issues of non-support and threats. But you're still not likely, even if you can get the threats, the confidential marital communication part, even in Mass, you still may be protected. But it can't be a threat. It's got the other parts of it are still protected, the confidential marital communication part. I lost you?
You lost me until the last sentence.
Well, we confidentially discuss other things, but part of it includes the threat. While the threat might be disclosed, the other parts of that very same conversation still may be protectable. What did we start arguing about, in essence? You got me? Okay. Okay, so anything else on that? Yep.
Does it matter if it's a criminal or a civil case?
No, and this is important, because the next phase of our analysis, it is going to matter. Right now, this is for civil and criminal. This is for all cases. Okay? Let's go to the second half of the rule. If it is not a confidential marital communication, it's everything else. Everything else. What we normally call the transaction and observation rule, but that's my fault, because I call it that and others call it that. It's too limiting, okay? You need to think about it as everything but a confidential marital communication, right?
If it's conversation is confidential between two spouses, and then one spouse blabs to someone else after the fact, does that break the confidentiality?
Doesn't break mine. We're married. She chooses to tell her friend about our confidential marital communication. I haven't lost my protection. She may have created a waiver of her own, but I haven't lost mine. On a confidential marital communication, the rule is either can protect that forever. I haven't waived any of my confidential marital communication simply because she yacked to her sister or her friend. Maybe she's created a waiver, but that's on her, not me. One person can't decide that the other has lost that protection. Okay? So if it's not a confidential marital communication, it's everything else. What do we call a transaction and observation? But you've got to think about it as anything else, anything but a confidential marital communication. The reason I'm saying that is it's not just what I see or what I hear, but it could also be premarital communications, right? Where things we talk about prior to marriage would be covered under this rule. If it is something other than a confidential marital communication, there's two preconditions to see if there's any protection at all. The parties must be married at the time of trial. If they are not, the analysis is over. It must be a criminal trial. If the parties are married at trial, and it's a criminal trial, then the rule is you need a mnemonic. It's SEFW. SEFW. In state court, either can prevent the other spouse from testifying, and in federal court, that right belongs to the witness spouse. SEFW. State court either can prevent the disclosure of that information. Federal court, that right belongs to the witness spouse. So it depends on them being married at the time of trial, and it's got to be a criminal trial, so there's no protection for civil cases for this rule. And then it depends on what court we're in, because depending on what court we're in, that right belongs to either both spouses in state court or only the witness spouse. So in essence, the witness spouse in federal court could choose to testify about transactions and observations and premarital communications, but the party spouse would still be able to protect confidential marital communications. You have questions on that? Yep.
So in civil proceeding, you're going to be protected with the confidential communications.
Louder.
You'll be protected by the confidential communications, however, they will not, transactions and observations will not be protected. They'll have to testify.
The only protection you're going to get in a civil case is for confidential marital communications. Right? Makes it easy for you. And again, you guys have to think about what they're going to do is test at the margin. So they're married just prior to the criminal case, and they want to testify, or they want the spouse to testify. Potentially could, and again, there was talk about Aaron Hernandez marrying his fiance prior to the trial. He'll never get permission. Now, especially now, he's on trial already, just started Friday. In order to try and take advantage of potentially this rule. Could he, if he had married her at the beginning of the week, could he preclude her from testifying about everything?
No.
Their private communications?
No.
No, you must be married.
Whoa, wait a minute. Can we try this? Before, see, after doing this nearly 30 years, I actually have to apply the law before I can come up with an answer, but you guys are able to do it faster than me. So they married at the first of the week. Is it a criminal trial?
Yes.
Married in existence at trial?
Yes.
State court or federal court? State court. Either spouse can prevent the other from testifying. Period. Right? It's a rule of disqualification. And listen, here's the reason if you need to think about why this would exist. If we're married and my wife chooses that her get-out-of-jail-free card is to dime me out and send me away for 10 years, we're over, okay? We don't need much more than that. The idea is we want that marriage to be preserved. And so one spouse testifying against another is likely going to destroy that relationship. And so the law favors the relationship. And if, on the other hand, we're in federal court, the reason they follow the rule, they say, listen, if one of them wants to testify against the other, there's not much relationship there anyway, let them go forward. And so we have the difference between the two. But if the marriage is in existence, the idea, at least in state court, where we look at either, is let's try and preserve that relationship even over the receipt of what is likely very valuable information. So this is a rule of disqualification when it's a criminal case and the marriage is in existence at trial. The reason on confidential marital communications we don't care that the marriage is in existence at trial is that we want partners to a valid marriage to be able to talk about things that matter. And then to protect those even well beyond the existence of the marriage in order to try and encourage, some type of dialogue during marriage. And so the rule differs. So this is a rule of disqualification. Yep.
In your example, she would still be compelled to testify about conversations they had prior to the marriage, right?
Nope. No, this second part of the rule is a complete rule of disqualification. The reason we set it up so that it's confidential marital communications and everything else is that confidential marital communication rule is kind of broad and protects it even after divorce. But this other part of the rule, where we talk about transactions or observations, and I said it also includes premarital communications, it includes everything. Absolutely everything. It's a rule of disqualification, meaning the witness is going to be precluded from testifying. And so it's that sweeping. Go ahead.
Well, in your outline, under confidential marital communications, you have while they were married, conversations prior to marriage or conversations which occur subsequent to a divorce.
That's precisely what it says.
But it's not right?
It is right. That part of the rule is not the rule that we're applying in this case.
Oh, all right. I thought you were on confidential communications.
No, we sort of are. But this is what I need you to understand. We separate out the confidential marital communications because they are a protected and protectable area to a much greater extent than anything else. It's a very easy rule to apply. Put those aside. When we have this other situation where it's a criminal case and marriage is in existence at trial, and we're asking a partner to that marriage to testify, that rule is what we call a rule of disqualification. Other than their name, if we can invoke the rule, the person doesn't get to testify. Period. It's that sweeping. So it's going to be all-encompassing in that situation. It is a rule of what we call disqualification. The witness isn't available then to testify. State court either can prevent that witness from testifying. End of sentence. In federal court, the witness can choose not to testify, or can choose to testify, but even in the situations where that witness chooses to testify, the party spouse can still protect their confidential marital communications. Okay? Yep.
It's not a criminal case, then.
If it's not a criminal case, that makes it easy. The only thing we can protect are confidential marital communications. But they're going to test the criminal case because it's trickier. They're going to test post-divorce or pre-divorce. They're going to be state court, federal court. They're going to play at the margins. That's the nature of this. Or they're going to involve more than one privilege like we did accidentally when we started this, which is, okay, it's not marital privilege, but maybe there's a Fifth Amendment privilege with respect to Mrs. Hernandez, if they were married, to testify. They're going to use more than one privilege, perhaps, that you have to work with. But this part of the rule is pretty straightforward. You good with this, or you need an example? Yep.
To rehash, if Hernandez married the woman last week, then she wouldn't be able to testify.
She could choose not to testify, because we actually flipped that rule in Massachusetts. We say the general rule is state court either, federal court witness. Massachusetts, we provide that right to the witness, not to either. So she could choose, if they had been married before, if they had married even today, which they're not going to get permission to, but if they were married today, she would have a right not to testify, period, against her husband. Because the law favors the relationship, and obviously testifying against the other partner to that marriage would harm the relationship if they were married today. Not just about things they talk about once they're married, but things she knows and saw beforehand, things he told her beforehand, everything. He would have a right, or she would have the right in our jurisdiction. We follow the minority rule, which says the state court, that right belongs to the witness spouse. But the mnemonic you want to use for the MBE is SEFW. State court either, federal court witness spouse. That's the rule. Okay? And by the way, let's assume they were married and then divorced. And he told her things, confidential things, like, I shot him. The bastard was blabbing his mouth. I had to kill him. Privately. Confidential marital communication, even if they're divorced. Obviously, it's highly relevant evidence, maybe essential to the government's case before they're done. Not a lot of confidence in what's going on down there. Could you still keep it out? Confidential marital communication. Either, even if she wanted to testify, even if she was dying to testify, either would be able to prevent that communication even post-divorce. Okay? Yep.
Under circumstances when it's questionable whether or not the conversation is confidential.
Oh, sure. Sure. Confidential is you want to look at the call of the question, right? It's the call of the question doesn't just dependent on the law. It's dependent on the facts as well. So that, if these guys could be expected to overhear it and did, then you'd say that's not confidential. If there are children there, I don't know, how old do you want to make them? You make them. How old are your kids? How old are the 3 kids? These are the 3 kids instead of being their age. How old are they? 2, 7, 12. Does that destroy the privilege?
Yes.
Which one? All 3? 7 and 12? 12 definitely, right? 7?
They're able to understand what
2? You're out. No, right? And I agree, Brenda. I think I would apply that. I would think that's a pretty good analysis on that. Obviously, there should be some reasonable expectation of privacy in what you're doing. But the example I've used in other years is, even if we're at the front and we are speaking privately, that you shouldn't be expected to overhear. But Charlie in the back row's got one of those little parabolic ears. He says, "Oh, this should be good." As the majority rule says, the eavesdropper doesn't destroy the privilege because we shouldn't be expected that he would hear it. Marco?
What if you're mistaken about your expectation? For example, when...
Yeah, someone's on the other side of the wall?
Well, no, they leave the mics on sometimes and the politicians say something to...
Yep. Well... I don't know. I mean, that's right, because we've had this problem with Professor Martin with the microphone this year, just like Naked Gun. I don't know what the answer is to that. What do you guys think? The portable microphone you forget is on. You're saying, you know what that bastard did. I don't know. I really don't. I do not know. We'd have to do some research on that to see. You have a reasonable expectation of privacy. My answer, I'm going to give you an answer, whether right or wrong. I think you should have known better, right? You had a mic on, you knew it was on, you didn't deactivate it. That's not a reasonable expectation of privacy when you're blabbing to the world at that point in time. But I don't know. I could see we could find a case that might go the other way on it. But I think my answer is right. What do you think? Don't you think? Yeah. But I think if someone's on the other side of this wall and I don't know, because these walls are kind of thin sometimes, I think that's okay. Or if we come in here and, someone's over there, I think there's still a reasonable expectation. But I think that's very fact dependent, and that gets back to Renee's question is, at the end of the day, you've got to take a careful look. I think some of them will be fact dependent like that you've got to make a call. And so I would be cautious, obviously, about excluding privileged information if there isn't that reasonable expectation and it shouldn't have existed, because we're excluding what likely is highly relevant evidence. And so you should be careful to protect your privileged information. And if you aren't careful, and we have this in a bunch of different situations, whether it's attorney-client or marital privilege or Fifth Amendment, if you aren't vigilant about protecting it, you lose it. So I'd use that as a sort of a caution here to say it's not so sweeping that you can never lose it, because you can waive it, frankly, at times quite easily. Was there, of course, someone else have their hand up over here? Oh.
Just want to make sure I'm understanding this right. So married, criminal case, even the observation you said is affected?
Everything is affected. The first part of the rule is relatively narrow, confidential marital communications. The second part of the rule is incredibly broad. That's it. Okay? Now, this was the easy handout. Now we got to go to the hard one. Okay, we're going to do character, habit, impeachment. Now, character, habit, impeachment is by far the hardest area we do with evidence. So you've got to go over this handout again and again. You've got to think about this lecture more than a few times. And you've got to really start to apply it to the questions. But at some point, you can only get so good in this area. And unfortunately for you guys, it is the second largest tested area in the evidence section now on the MBE. And the reason they've increased it is because they know how difficult it is and they want to make the bar exam harder. So while hearsay is the first most significantly tested area, and that's the area we can get the most bang for our buck in. This area is the second most tested area, and it's areas. That's what is a little bit misleading and makes it difficult, is this isn't tightly wound together. This is a bunch of different areas that we all put together, call it character, habit, impeachment, and expect you to be able to make more sense of it. And the problem is it's a bunch of unrelated areas that all tend to be lumped together, and that's what lends to its confusion. The best way to deal with this section is to get the general rules down, to apply them then firmly, and you can't worry about the last 5% of this, because it is a very, very difficult area. But there are some general areas on character, habit, impeachment that if you get down will make a lot of these MBE questions 10 times easier and hopefully get you to the right answer. And that's what I'm hoping that we'll be able to do and you'll do over the course of the next 2 weeks. Character. Character is almost always going to be a criminal case situation. So when we're looking at an MBE question, if it's an attempt to offer character in a civil case, it's likely inadmissible. The reason for that is there are very few cases, civil cases, where character is relevant. Defamation, for instance, is one of the few civil areas where character is relevant. If you think about that. If everyone already thinks you're a POS, then you can't be defamed. You're in essence defame proof. So your character is important. But that's it. You know, it's not your character when you want to drive fast and you get into an accident. So I've seen questions like that on the MBE where, you know, he's known as Dan the Daredevil because he drives so fast. That's irrelevant character evidence in a civil suit. Most times in a civil case, character is going to be irrelevant almost all times, except for maybe false imprisonment and definitely defamation. So character is almost always going to be criminal case. And here's a very important thing to understand. Even in the criminal cases where we do see character evidence offered, the accused has to first raise the issue. So if the government attempts to offer character evidence during its case in chief, it's inadmissible. The accused has to raise character as an issue in order for it to be an issue. What type of character evidence can the accused offer, and how do they do it? The accused can only offer character evidence that's inconsistent with the crime charged. That's the type of character that the accused can raise. So, for instance, if the accused is charged with a violent offense, then the accused can offer opinion evidence, people who know their reputation in the community, for peacefulness. You can only offer character evidence that's inconsistent with the crimes charged. And the accused is the one that has to first open this door and raise it. And you raise it through general opinion testimony of people who know your reputation in the community. Now, it doesn't make a difference whether you like this evidence or think it's trustworthy or not. The rule is what it is. I frankly, how many times have we seen on TV where people say, I was his next door neighbor. He was a guy who plowed my driveway. He was a nice guy. I never would think he'd do something like this. So to me, I don't find it very powerful. But the rule is what it is. You can call people who know your reputation in the community to testify that your reputation is inconsistent with the crimes charged. For instance, this individual who is alleged to have killed 3 people in North Andover this week, he would have, and I've already heard those witnesses come on the TV and say, what a wonderful guy. Never would think he'd do something like this. Everyone thought he was a gentle giant of a man. That type of evidence, you could call witnesses to offer that testimony because it's inconsistent with the violent offense that's offered. Character, inconsistent with the crime charged. Once the accused has raised that character issue, now that character is fair game. Now the government can call witnesses. Now the government can impeach that witness. Once that witness has testified, the government could ask that witness about specific acts that are inconsistent with what the witness has testified to, testing the breadth of that witness's understanding of the reputation. I know you testified that he was a gentle giant, that was his reputation in the community, but did you know 2 years ago he beat someone with a baseball bat so badly they were hospitalized for a month? No, I didn't know that. Did you know he once chewed a man's ear off in a fight? No, I didn't know that either. Right? You can now test that witness's knowledge by asking about specific bad acts inconsistent with the character reputation. That witness who's testified, just like every other witness in every other case who testifies, when they take the stand, yeah, I know, a little short my table here. What the heck? Uh-oh is right. There we go. Okay. Because here's something else for you to think about. We're talking about general character here. Your reputation, who you are or who people think you are, really. Every witness, every case who testifies places what we call their character for truthfulness in the stand, by taking the stand, when they promise to tell the truth, their character for truthfulness is impeachable now, right? Because they've promised to tell the truth. They've said they've taken the oath. So when this witness has told us about their knowledge of the person's reputation, not only is the accused character, general character, an issue, but this witness's knowledge of that character is an issue, as is this witness's, like every other witness in every other case, character for truthfulness an issue. So there's a lot that's fair game here. Yep.
Just to clarify, so if you have a defendant who has a character reputation witness on the stand, and the witness says he was a nice guy, and then the prosecution...
Can't say he was a nice guy.
Or let's just say he's a character witness for the defendant, and then the prosecution...
Well, wait. Character witness for the defendant who says what? What's the crime?
Assault.
Okay.
And
he says what?
I didn't think the defendant was that way. I've never...
Nope, can't say that. Can't say that. This is why I'm asking you to articulate it. Charlie can't say, I didn't think Mike could do this. We don't care what Charlie thinks, right? We don't care what a lay witness thinks. What Charlie can testify is, this is rumor and innuendo, okay? But Charlie can testify, I know his reputation in this community. Everyone thinks he's a very peaceful, gentle guy. That's what he can testify to. He can't give us his opinion.
So if he doesn't give an opinion, and once he testifies that way, the prosecution can then say, did you know that 3 years ago he was arrested and charged and arrested for assault of another person?
No.
No. Okay.
No, but for an important reason. My questions were phrased differently. It wasn't that was he arrested, it's that he beat up someone. He chewed a man's ear off. The fact that the police choose to arrest you doesn't mean you did it. It means that someone might have thought you did something, and that's not sufficient evidence. In order to impeach, I'm making an evidentiary distinction more than a factual distinction for character evidence. If you want to ask Charlie now whether he was aware I did certain things, that's fair game. If you want to ask Charlie if he's aware that he thought, this guy thought I did certain things, that's not fair game. Do you understand the distinction?
I think so, but I'm not phrasing my questions right, but I think my question really is, once it's pointed out on the stand and the witness makes a statement about the defendant, the door is then open for the prosecution to ask about prior acts.
Yes, by offering character witnesses, the accused has now opened the door to his character itself. And so now, those prior acts, and they don't even need to be charged criminal activities, not convictions. All you got to do is have a good faith basis to ask the question. You have now opened the door to your character by placing those character witnesses on the stand. And so Charlie can be impeached in a variety of ways.
So it would be more than just impeachment, though. It would be maybe proof of motivation to commit a crime and impeachment, or impeachment of the witness and the defendant, both, or just impeachment?
It's just it's just impeaching Charlie. First of all, and there's a couple things that we got to think about in this area that become important in the analysis, and that's why I'm trying to be. I want to make sure we're precise with the language. First of all, by putting Charlie on the stand, the accused hasn't testified. So you can't impeach the accused until the accused actually testifies. So it's not impeachment of the accused. When Charlie testifies, let me go back and do this, because that's where when I put the chair on the stand, I wanted to open this door, and it's probably where we should have done it. And it's in the 5-part test, which is online for you to think of and to listen to and think about as well. Let me take a step back for a minute, and I think then we can get back here. Charlie takes the stand. It's any case. Charlie's just a witness. Forget that this happens to be character evidence, because then we'll get to that. Charlie happens to take the stand in whatever case it is. And he promises to tell the truth. He's testified. What's the scope of cross-examination? What do you got for me? Okay, B, C, D, right? B, C, D. Bias, credibility, and the subject matter of the direct exam, right? Scope of cross-examination under the Federal Rules of Evidence. B, C, D. Bias. That you are the party's mother, brother, lover. That you have an interest in the outcome of the case, a financial interest, that you've been paid to testify today. Any reason that would develop a motive to lie. Bias. Credibility. Things bearing on your truthfulness. For the purposes of items bearing on your truthfulness, your prior convictions, which we're going to talk about in a little bit, can be inquired about. Less than 10 crimin falsies, no discretion to exclude. More than 10 felonies, court is going to balance it. We're going to talk about it in a little bit. But your prior convictions go to your credibility. Your prior bad acts that are probative of truthfulness can be inquired about. Isn't it true, Charlie, you lied about cheating on the Civ Pro exam last year? Isn't it true, Charlie, that you gave a false statement to Dean Sullivan? Isn't it true you lied about this or that? Prior bad acts that are probative of truthfulness. Isn't it true you lied on your application to law school? Prior bad acts probative of truthfulness we can inquire about. Credibility. We also have the ability to call other witnesses who know of his character for truthfulness in the community, who can say, I know Charlie's character for truthfulness, it's bad. He's known as a liar. The D, the subject matter of the direct exam. When we talk about the subject matter of the direct exam, if he's supposed to wear glasses and he didn't, if he's supposed to have a amplifier so that he hears better and he didn't wear his hearing aid, that's relevant. We can inquire about the parts that he didn't tell us about on direct that he supposedly saw or heard. His entire direct exam is up for grabs. Which that means as well, if there are prior inconsistent statements Charlie's made, we can inquire about them. Right? We can try to impeach him through B, C, D. Any witness, any case, who has promised to tell the truth, and that's what a witness must do, they can be impeached through B, C, D. Bias, credibility, the subject matter of the direct, which is going to be pretty sweeping. In this case, when Charlie has testified about character evidence, my character, that's inconsistent with this violent offense I'm charged with, as part of D, the subject matter of the direct exam, they can also inquire about, of Charlie now, specific acts that I have committed that are inconsistent with that reputation Charlie said he's heard of. And they're not offering it in essence, but of course sideways it does, to attack me. They're offering it to say about Charlie, you don't know Coyne like you think you know him if you don't know these 5 things that are all very inconsistent with this peacefulness that you've just testified about. That's why you can use those prior bad acts to attack how well he knows him. And it comes in under, in essence, under D, the subject matter of the direct exam. The government can also call, since I have opened the door by calling Charlie, the government can also call other witnesses who know of my reputation in the community. They call Jonathan and say, I know his reputation. It's very, very bad. He's considered damn dangerous, and especially if he's been drinking. I've opened the door. You've put your character in evidence. Now, relevant character evidence. Character that's inconsistent with the crime charge can be offered by the accused, but the government can not only try to impeach your witnesses, but they can find other people who have a different opinion as to what people think of you in the community. Okay? Okay on character? This is, you always have to make a slight distinction between character for truthfulness, which is an issue in every case with every witness who testifies, and general character like this that's only can be offered inconsistent with the crime charged by the accused, but then you've opened the door to character evidence generally. Yep.
In your hypo, if you call a witness to challenge Charlie's reputation, is that a collateral issue?
Nope.
Or does it open the door to...
Nope, don't forget that collateral issue for right now. We're going to get to that in a minute. That's when we talk about those specific acts and the like. I can do that. You know what? I'll give you that right now because this is a very difficult part of the test. You know when we were asking Charlie about, isn't it true you lied on your application to law school? We were asking Charlie, as we could, any witness in any case, about their prior bad acts that are probative of truthfulness. Okay? And by the way, you guys don't like this rule. You don't have to. You don't have to like all the law that you got to apply, but you got to apply it, right? So there's a rule that you can inquire of a witness who testifies about their prior bad acts that are probative of truthfulness. That's the rule. Okay? Here's what you don't like about it. I don't need a criminal conviction. I don't even need a charge. All I have to do is have a good faith basis to believe that it existed and ask about it. So Charlie lied. He said he had a 3.5 and he wasn't even close. Okay? I have his transcripts from undergrad. It's like 2.0000 something. That's it. It's a one-witness case. He said, she said. One on each side. Charlie's credibility is essential to this case. He gets up there and he testifies. And he looks good, you know? He looks believable. He looks like he's telling the truth. Cross-examination. First of all, can I ask the question? Charlie, isn't it true? Now this is what do you want it to be? A motor vehicle case? Let's make it a motor vehicle case. Cross-examination. Charlie, isn't it true? This is 10 years later now. Isn't it true you lied on your application to law school? Any objection? A bunch of wimpy lawyers. Not even try. Here, you know where I'm going. No objection.
Objection, relevant.
Thank you, Marco. It's about time. Okay, objection, relevance. Why is it relevant? I just told you why it's relevant. Why is it relevant? Prior bad act that's probative of truthfulness. That's the rule. Can you inquire about prior bad acts that are probative of truthfulness? Yes, I just told you that was the rule. Marco's objection is overruled. It does seem like, what the hell does this have to do with an auto accident? And the answer is nothing. But it is a prior bad act that's probative of truthfulness, and I should be able to inquire. 403 he might have done better with, because, well, still probably coming in. Charlie says, because he's not just a liar, he is a pathological liar. Charlie says, nope. Nope. Got a 3.5. Oh, all in, Charlie. I've got the transcript right here. A one-witness case. Explode him up. Show him he just lied direct to your face. He must have lied about everything else. Can I introduce the transcript? No. The answer is no. Okay? And this is Brenda's question. On a prior bad act that's probative of truthfulness, while you can inquire about it, the inquiry ends with the question, because the rule is you can't introduce extrinsic evidence on a collateral matter, period. I'll explain what that means. Extrinsic evidence simply means evidence from other than the witness's own mouth. Collateral means it wasn't relevant to the initial case of PVD. Who caused the auto accident? Does this have anything to do with red light, green light, who was negligent, or anything along those lines? It doesn't, right? And here's what my cynical view of the world is. If we chase every little lie that a witness tells on the stand to its natural conclusion, trials would take forever. Now, Charlie has clearly perjured himself. He's an essential witness. But then if the DA wants to pursue it, they can, because that's a different case. But at the end of the day, while I can ask the question, the inquiry ends with the question, even if I have completely 100% proof that Charlie's lying right now. Since it's collateral, it wasn't relevant to the initial suit of PVD, the inquiry ends with the question to Charlie, and that's it.
And if Charlie admits it?
They say what?
If Charlie admits it?
Yep, that's it.
Doesn't do it?
No, I don't need it. Either way, I don't need it. Right? If Charlie admits it, Charlie says, yeah. Yeah, but I've been doing okay since then, huh? Right? If Charlie admits it, I got it. And if he doesn't admit it, I'm moving on anyway. That's the rule. Right? To think about it logically, do we really care that he did? I mean, do they care in this auto accident case what lies he's told over the course? No, you can ask, and if he admits it, great. But the problem is with the pathological liar or people who are just going to lie, you say, son of a bitch. But that's the rule. The rule's the rule. Okay? So, by the way, this is a difficult rule to apply, but you've got to think about it because they test it. It's heavily tested. So not heavily. It will be tested. You'll at least get one question on it. So what you've got to remember is while we can inquire about prior bad acts that are probative of truthfulness, the inquiry will end with the question. You can't introduce extrinsic evidence on a collateral matter. Extrinsic simply means from other than the witness's own mouth. Collateral means that it wasn't relevant to the initial case. The reason you got to focus on it and think about it like that is because in your mind, and I think correctly, it has clearly become relevant now, right? This is a one-witness case. If I can explode him, I win. That isn't what makes it relevant. Go back and look at the initial case of PVD. Under those circumstances, if it was relevant initially, you can offer it now. If it wasn't relevant initially, it's not now either. Okay? Habit. Systematic and routine practices come in to show you acted in conformity with that practice. You prove habit, unlike character, by offering information about the specific habit you want to prove. When we had evidence together, first day of evidence class, he put that chair up on the table. Every time we talked about hearsay, he put that chair on the table. That chair falls on someone when none of us are here. Who the hell put the chair on the table? The likelihood is we're going to offer character evidence about, habit evidence about who generally would put that chair on the table, and it's going to come in to prove the likelihood is I put that chair on the table. Habit is almost always routine business practices. Letters date stamped upon their receipt in the upper right-hand corner, right? Think about some of your practices at your various businesses. It's oftentimes business practices, but you're going to have to show them through specific instance of that business practice. That's the rule. You prove habit by specifics, you prove character by generalities. So that's a big difference. But habit could also be personal habits. There's a bar exam question I saw that every day the guy wakes up at 6 a.m., goes to his bathroom, brushes his teeth immediately at 6, and while he's doing that, he looks out the window. He sees something happen. What time did it happen? 6 o'clock, because that's habit. Habit is not just business practices, it can be personal practices. You prove it through specific instances of conduct. It comes in to show the person acted in conformity with their habit. It's not character, it's not habit, it's other crimes, wrongs, or acts. It's what Younger describes as the brides in the bathtub rule. What it says is that prior events that provide any one of the following: a link to motive, opportunity, intent, common plan, scheme, design, lack of mistake or accident or identity of the perpetrator, come in to prove this person's connection with the prior events. Sometimes referred to as the mimic rule, but mimic doesn't have enough of the letters there, but that's what it's been referred to. We had a mnemonic, Miami cop. There's another one that someone gave me. Whatever one works for you is great. But if it shows motive, opportunity, intent, common plan, scheme, design, lack of mistake or accident, those prior events can come in. I'm going to use Younger's example of brides in the bathtub because I think it's particularly illustrative. Young guy marries a wealthy older woman. Night after their honeymoon, she's found dead in the tub, her neck snapped like a twig. He comes into a fortune. Accidents happen, he moves on. 5-10 years later, he's out of money, marries another wealthy older woman. Next morning after their honeymoon, she's found dead in the tub with her neck snapped like a twig. He comes into a lot more money. Accidents happen, what are you going to do? He goes for 3. When the third wife is found with her neck snapped like a twig, he's arrested and charged with the murder of wife number 3. But only wife number 3, not the first 2. Can the 2 prior events come in during the government's case? And are they admissible? And the answer is they are if they go to any one of the following: motive, opportunity, intent, common plan, scheme, design, lack of mistake, or identity of the perpetrator. The reason the brides in the bathtub rule is a good illustration is it probably could satisfy about 4 of those. All it has to do is satisfy any one of them. Government can offer it, and it comes in to show the defendant is guilty of the crime charged. Sometimes referred to as the signature crime case. It has to be a unique signature if you start to think about it. Just robbing a store with a gun is not unique enough. Robbing the store with a pearl-handled revolver, maybe it is. Raping people isn't. Raping people in a certain way. Perhaps we're going to have common plan, scheme, or design. You've got to look at it carefully if you're going to apply this rule. But this rule doesn't require the accused to testify, doesn't require the accused to offer character evidence. All it requires is a link to establish one of those items to the party in this case, and you can offer that evidence. Questions on that? Yep.
So even though, let's say you're not able to offer 4 rapes in a rape trial because of the probative value of the witness, but you could offer it if the guy used a red scarf to bind the hands or what have you? Yeah,
I'll just use, they used to have a bar exam question, they took it out, obviously not PC. Someone dressed as Uncle Sam would commit rape and have the victim sing the Star Spangled Banner under these circumstances. 3 prior times, that's what they did. Gets out of jail. Another rape is committed with someone dressed as Uncle Sam, and the victim is required to sing the Star-Spangled Banner. Can the 3 prior events that this person has been linked to come in to show either the identity of the perpetrator or common plan, scheme, or design? And the answer is yes. And so that's obviously the pluperfect example. How much down that road you go, I don't know whether a red bandana is enough, but that's what you're looking at is something that so clearly ties this person to those events. There's another bar exam question where someone is shot with a rifle, a handgun, and something else at various times, and they say, no, that's not common plan, scheme, and design. They like to shoot. That doesn't, you're going to have to get a lot better than that to show this close relationship between the prior events and this one. Okay? Questions on that? Okay, let's go to the impeachment. We already talked about BCD. I want to go specifically to the credibility with respect to prior convictions. Impeachment with prior convictions. At common law, if you were convicted of a crime, you could never testify again because you were considered untrustworthy. When they drafted the FRE, they said that rule is too broad, and so they compromised, and they said, okay, if someone's been convicted, let's establish some rules for when those prior convictions can come in. And that's what we are working with here. Anytime you're looking at your evidence rules, it is vitally important, for the purposes of the bar exam especially, to try and look at when the court's hands are tied. Because in trying a case, we give the trial judge a lot of discretion because things happen too fast, right? We get an objection, the court has to rule in less than 30 seconds, they move on to the next issue, and then there's another one, and another one after that. So, a lot of times, in our cases, the court's going to say, well, it's on the attorney because you didn't protect your record. So you want to look for that. But you also want to look for when the court has discretion to do certain things, and more importantly for the bar exam, when that discretion doesn't exist and their hands are tied. Because that's highly tested because it goes against 95% of evidence law. So when the court must do something, that's frankly, if I were taking this test again, that's a list where I would make those 15 examples a list so I can say, okay, that's important to focus on because that's such a significant exception to the general rule they like to test it. One of the areas is right here, okay? When we're using prior convictions, it makes a difference whether they are 10 years old or less or more than 10 years old. If it's less, 10 or less, conviction for a crimen falsi. Crimen falsi is just a crime involving a false statement or dishonest act. Less than 10, crimen falsi. The trial court, has no discretion to exclude it. Can't. That's an important distinction, and that's one of the distinctions where the court's hands are tied that they like to test. So suppose someone is on trial for mail fraud. We've got a prior criminal conviction for perjury and a prior mail fraud conviction. Less than 10 years old. Witness testifies, the accused testifies. May the trial court exclude those 2 prior convictions when asked on cross-examination? No. Why? Because they are crimen falsis, crimes involving false statements or dishonest acts. They have an absolute right to use them if the accused testifies. So if the accused doesn't testify, that's one way to avoid the use of these convictions. Because the convictions aren't offered to say they're the type of person likely to commit crimes. They're offered to say they are liars, having been convicted of crimes. So, less than 10. If it's a crimen falsi, no discretion to exclude. once the witness testifies. None. 0. If it's less than 10 and a felony, and it's got to be a felony, so we don't do misdemeanors unless they're crimen falsies. Less than 10, felony. If it's a witness other than the accused, then it can be excluded upon a showing that it's substantially more prejudicial than probative. If it's a witness other than the accused, those convictions can be excluded upon a showing that they are substantially more prejudicial than probative. If it is the accused, they can be excluded on a lower showing, simply by showing they are more prejudicial than probative. We favor the right of the accused to testify without these convictions. So it is easier to exclude the prior convictions of the accused than another witness. And they can be excluded, less than 10 felonies, simply upon a showing of more prejudicial than probative. So an accused is on trial for rape. Committed 3 other rapes in the last 10 years, 2 other rapes in the last 10 years, and sentenced to jail. The accused wants to testify. Says, I didn't do it. Call of the question. May the trial court... Well, first of all, tell me why those 2 prior convictions would be offered once the accused testifies. What are you offering them for as the government? Go ahead.
Show that he did it before, so he probably did it again.
No, Charlie.
Well, that's why it wouldn't come in, right?
That's why it wouldn't come in. Why are you, in essence, offering it? Why is the government offering the 2 prior felony convictions for rape? That they're not. That's not why they're offering it. Why are they supposed to be offering it? Impeachment, which says what? Yeah, you're not an honest person. Is the jury, as we've heard from our esteemed lawyers here in the front row, is the jury going to confine the receipt of that evidence to saying, oh, he's a liar? No, they're going to say he's a rapist. Once a rapist, always a rapist. They're going to convict him. Those convictions aren't being offered to say rapist. They're being offered to say liar. And this is the problem with them. So here's your call of your question. May the trial court allow those convictions to come in? We're going to vote. Yes. May. Yeah, for Christ's sakes. May, yes. May the trial court exclude the 2 prior convictions for rape? Should the trial court exclude the 2 prior convictions of rape because they are more prejudicial than probative? That's the right, and I think all of those are the right answers, and that's why it's important to understand what this analysis does. When the crime is too close to the present charge, that they are likely to misuse the evidence, that's a reason why the court should be careful in exercising their discretion. The problem is they cannot do it when it's a crimen falsi. If it's a crimen falsi, the court has none of that discretion to exclude. Now, let's assume those 2 prior rapes were committed in such a way that they were so unusual that they would provide an identity of the perpetrator or common plan, scheme, or design. Now, even if that person doesn't testify, the government potentially could offer that evidence because it goes to motive, opportunity, intent, common plan, scheme, or design. He's dressed as a ninja, and the rape is committed at a certain hour in a certain community. You'd argue motive, opportunity, intent, common plan, scheme, or design, lack of mistake or accident, identity of the perpetrator, even if he doesn't testify.
That was just my question. So when it comes to something as a habit, the accused doesn't actually have to testify. The government can offer it anyway.
But this is not, when I talk about motive, opportunity, intent, common plan, scheme, design, lack of mistake or accident, or identity of the perpetrator, that's not technically habit. Those are prior circumstances, prior events that, because they provide one of those links to the present event, say that this is the person that likely has done it.
And in that case, the accused does not have to.
Accused doesn't have to testify at all for motive, opportunity, intent, common plan, scheme, design, lack of mistake or accident. Or even habit if they can offer it. But the accused doesn't have to testify at all in order to admit it under those circumstances. More than 10-year-old crimes. And now here's what they like to test too. Because when it's more than 10, even crimen falsies get swept into this mix. So you can exclude a more than 10-year-old crimen falsie if the court has to find, in order to admit a more than 10-year-old crime, so we're talking crimen falsies and felonies, there must be advance notice of your intent to use the crime. So if there's no advance notice, it can't be used. And the court must find by specific facts and circumstances that it is substantially more probative than prejudicial. So the test actually reverses itself here. The court must find by specific facts and circumstances that it is substantially more probative than prejudicial. The likelihood is a more than 10-year-old crime won't be used. But what we can do, and this is again important to recognize, is that a crimen falsie that's more than 10 can be excluded. But when it's less than 10, a crimen falsie cannot be excluded, regardless of how prejudicial it might be. As I said to you when we... Yeah?
What if it's like really major, such as...
What about what?
What if it's like really major, like grand perjury, like flying to...
Grand perjury?
Like flying to the courts or doing something really horrible.
Okay, but perjury is a crimen falsie, right? It's the crimen falsie, the ultimate crimen falsie. So let's try a couple examples if you want to. So defendant's on trial for perjury. 3 prior perjury convictions, less than 10 years old. He wants to get up there and try one more time. Right? What the hell? So he gets up there and says, no, I was telling the truth. I didn't lie, blah, 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 blah. May the 3 prior convictions for perjury be used on cross-examination? Yes. May the trial court exclude the 3 prior convictions for perjury? No. Right? Why? Because they're crimen falsies less than 10. No discretion to exclude. And you know, perjury is the easy one. But what you have to do for a crimen falsie, it's any crime where a fraud or deceit is an essential element of the crime. So mail fraud, larceny by trick. There's a lot of crimes, if you start to think, not as many as we might think, but there's a lot of crimes where it doesn't have to sort of hit you over the head and say perjury, but there are other crimes where fraud or deceit is an essential element of the crime, and it doesn't make a difference whether that's a misdemeanor or a felony. If it's less than 10, there's no discretion to exclude it. And that's why the court grouped these crimen falsies together and said no discretion, because they're the types of crimes that cut at the heart of whether someone's truthful or not if you've been convicted of crimes involving fraud or deceit. That's where they compromised and said, okay, we'll let them testify, but we also want the jury to understand what these prior convictions were for. Yep?
I don't want to confuse the issue, but going back to what Brendan asked about the collateral and extrinsic.
Not with I meant to say that at the time. On convictions, it is not considered extrinsic evidence. If Charlie says, I was never, ever convicted of perjury, he's eaten that paper. That's not considered extrinsic evidence to prove that I've got a prior conviction for Charlie for perjury. He doesn't. That's not a freebie when he says never happened. I can prove prior convictions with the actual evidence if he doesn't admit it, and I can even call other witnesses, because that's not considered a collateral matter.
That really wasn't my question.
Yeah, but I want to make that point. That was my point.
Assuming you've been excluded or precluded from entering a 10-year-old or past 10 conviction, can you still inquire about his truthfulness? Like, not asking about the conviction, but isn't it true you engaged in mail fraud 12 years ago?
I think you can, but this, yes, you can, as a matter of fact, because we don't, on prior bad acts, we don't put an age limit or a time limit like we do with less than 10, more than 10 for convictions. But if you think about it philosophically, I would still be arguing then that it becomes a 403 issue. And frankly, if I had that worry, I would be doing it by way of a motion in limine. Okay, I'm going to keep out your 12-year-old mail fraud conviction. I also want to make sure, by way of a motion in limine, that there be no inquiry about the events that gave rise to that conviction as well, because otherwise you are, in essence, backdooring the excluded event simply because it also classifies as a prior bad act. But in fairness, prior convictions obviously likely involve prior bad acts. There's certainly enough of a good faith basis to ask about it. So I would be more sweeping in making sure that not only am I keeping the conviction out, but the underlying details as well you can't ask. But that's a legitimate question. But there's no firm answer because without a ruling on a motion in limine, I'd be very careful about doing that, though. If the court actually excludes the 12-year-old conviction to now try and bring it in as a prior bad act, you're close. Huh?
You're just asking the question if he wants to lie.
Yeah, but if the court finds that it isn't more probative than prejudicial on the actual conviction, to now and try, I would be worried about trying to sidestep that order by asking about the underlying acts. I hear you. I would expect to get my ears boxed on occasion doing that. And I could see getting my ears boxed. Yep.
These rules, do they only apply to straight up convictions, or can you bring in, like, if it's continued without a finding, dismissible without prejudice?
No, it is a conviction, but the conviction doesn't matter whether it's pending appeal, but it's got to be a conviction. So if it's continued without a finding, that's not a conviction. I'm trying to think of, a pre-trial probationary period with a dismissal isn't a conviction. It's got to be a conviction. But the fact that it's pending appeal doesn't matter, by the way. By the way, 10 years old from the date of last incarceration or conviction, whichever is the more recent date. So if you were convicted 15 years ago but served 7 years, that's considered only an 8-year-old crime. Yep.
And the continue without findings, can you bring that in as a prior bad act?
Yeah. It's just it's not technically a conviction, right? Yep.
I'm just a little confused. The prior bad act, go back to that, and it's a collateral issue. But if it was a conviction and the person says, that never happened to me, you could actually use extrinsic.
Okay, stop.
I think I'm confused.
Yeah. You have to look at these separately, okay? So we've got prior convictions. But as pointed out, thank you, we have prior convictions. We have prior bad acts that don't involve a conviction or even a charge in many instances, okay? And so we treat them separately. As pointed out, though, a prior conviction likely also involves the commission of prior bad acts. So now we've got two arguments in which we can use to try and argue we can use that event for impeachment. And that's the way you have to look at it. But the problem comes in is when we exclude the conviction. Technically, we haven't excluded the prior bad act yet, and so we don't know. If you want to push it, then potentially you can ask about the prior bad act that is the cause for that conviction. I'd be careful, but you could. So what was the gist of your question?
So before you could bring in extrinsic evidence.
The only extrinsic evidence you're going to bring in when we're talking about the impeachment along the prior bad act or the conviction is the conviction itself. You can't introduce extrinsic evidence on a collateral matter. And that usually is what we're talking about, are these prior bad acts that are probative of truthfulness. What I would suggest you guys do, because I'll come back to this next Saturday, go over this handout a bunch of times and start to look at some of the questions, and maybe on next Saturday we'll be able to try and flesh it out a little further. What I'm telling you now, and I'll tell you, is that we could do this area exclusively for the next 2 weeks, and you'd move from here to here. Okay, this is not going to be an area where you ever feel 100% confident. I think the next area we do after we take a brief break, hearsay is one of those areas that we can get a lot of confidence and a lot of bang for your buck. But you got to get better in this area as well. And this is the most difficult one. This use of prior bad acts that are probative of truthfulness. That then under what circumstances can I introduce the extrinsic evidence? But that rule, first of all, just simply requires you to get the rule down, right? And then start to think about it a little deeper. The rule is, while I can inquire about prior bad acts that are probative of truthfulness, I cannot introduce extrinsic evidence on a collateral matter. And so then that just requires you to be able to define each of those pieces. Extrinsic evidence simply means evidence from other than the witness's own mouth. And what collateral means it wasn't relevant to the initial case of plaintiff versus defendant. And so you've got to go back and look at it and say, well, would this evidence have been relevant initially? Not that because we know it sounds relevant to us now if we use it sort of a non-lawyer's definition of relevance. It sounds relevant. The question is, would it have been relevant to the initial case of PVD? If it is, you can introduce evidence on it. If it wasn't, then the inquiry's done. And that's the way you've got to look at it. Colleen?
Can I get confused on when you do that analysis? Like if it was a 15-year offense,
Yep.
let's say they served 12 years.
Yep.
Would you call it a 3-year-old?
Yes.
Would it be better if it was 15?
It might be better, but that's not the law.
But it's, is that just confusing?
Really? Because okay, but
The math, it's the logic behind
okay, but hold on a minute. First of all, that rules on prior convictions, not prior bad acts. Because as pointed out by Rob, prior bad acts don't have a shelf life. We don't use the same thing. So what you're talking about is a conviction. Well, I can give you what I think would be part of the drafter's understanding of it. Do you think someone, for more than 10 or less than 10, if your conviction is more than 10, people must change. People hopefully get better. That's the whole idea, isn't it, over time? So at some point they say it's too remote in time. I think when they've said, it must have been a pretty serious crime if 15 years ago you were sentenced to 12 years in prison. And so therefore that has some greater bearing on your credibility because in essence you've only been in society now 3 years. And I think that's what they do the math for. But I don't see, to me, and I'm not so sure, I just don't, I think there's a logic to saying more than 10 or less, and then using it either from date of conviction, because if you don't serve any time and 10 years goes by, that says something. But if you served a number of years such that 10 is now down to 3 in your example, that has something, I think, some bearing potentially on your credibility that the jury should understand. And
the person got out of jail, served off 15.
No, that's correct, but if you served all 15 without any more convictions, then doesn't that say something about you?
So
Yeah, now you're in
the bar, are we likely going to see something confusing like that? Or just
Something confusing like what? Like the difference between 15 and 8?
15 years ago was, charged.
Shit, you're going to see a lot more confusing stuff.
For the sake of just saying, like, how old is the crime? Is it like...
No, okay, but that's easy. Seriously, this is the easy part. He's convicted 11 years ago. Doesn't serve a day in prison. That's an 11-year-old crime, right? He's convicted 11 years ago. Serves 5 years. That's a 6-year-old crime. That's the math. That's your math. Right? I mean, we're all... If he doesn't serve any, it goes from date of incarceration. That's it. Okay, oh, you good? No, seriously, that should be, that you should be able to knock out. That's the easy part of that rule. Okay? Right, Colleen, you good? Because am I missing a piece here?
Just it doesn't make sense if the guy serves 3 more years. A guy, he wouldn't have to include it. He could be excluded.
No, wait a minute. No. What do you mean? If he serves 3 more years, it makes it a newer crime.
15 years. He served all 15.
Well, if he serves 15, and it's all 15, then the date we use is the date he gets released from prison. He's got to go another 10 now. So he's got to go another 10 before we can't use that crime anymore. Oh yeah, it's the date of conviction or last date you are incarcerated. That's the date we start using. That's the most recent date is the 10-year rule. Does that make more sense to you? Okay. Okay, let's take 5 minutes and come back and do hearsay.
Handout should we prep on for Monday night?
Neither handout will do Monday.
What are we doing Monday night?
Whatever it says on the here. Yeah, you should be. Actually, I think we're starting the book, so you should be.
Okay, so I have a question.
Yep.
They came in the other day.
You tried what?
You said there's tapes. Buy the bookstore.
Oh yeah.
I've been trying to get to the bookstore, but it's been closed a lot, so I haven't got them. Are they online? They're not online. You'd have to actually go into the media lab and sit down.
Yep. Well, there's a couple of the lectures that are online now. They're not all online.
Are they on Twin?
No. No, I don't think so. I don't think that's where you put them. I think you put them right on our website.
Oh, okay. All right. But you can buy the book.
Yep.
Yeah.
I don't know, $40, I think.
And that will be the entire class.
For this one?
Yeah.
I don't know.
So your lectures are on Twin?
I don't think they're on Twin, are they? Is that where you put them? I think they're on the website. I think they're on MS Law.
I did go on Twin and see them.
The 2 ones you're looking for are on, I think they're on MS Law.
Okay.
So what do you just go out to where the course information, course material?
Yep, it's under comparison.
Okay.
You get my email yesterday?
I did. I think it's on his.
Yeah.
Okay, let's talk about hearsay. As I said to you, hearsay is a significant portion of the MBE. Before they added civil procedure to it, it was 5% of the entire bar exam. You're looking at somewhere now probably, it used to be as many as 11 questions. Now you're looking at probably about 8 questions are going to involve specifically hearsay and the various exceptions. Under the modern definition of hearsay, what is and what isn't, under the FRE, there is as much tested in 801 and testable as there are with all of the exceptions. You must know the entirety of the definition of hearsay as contained in 801, what is and isn't, because before you ever start to look for an exception, like an excited utterance or declaration against interest or any of the others, you have to run all of the 801 definition. Any out-of-court statement offered to prove the truth of the matter asserted therein is hearsay, unless it's a party's own statement offered against that party. That's the core we start with. Any out-of-court statement offered to prove the truth of the matter asserted therein is hearsay, unless it's a party's own statement offered against a party. Any statement made by anyone, anywhere, other than while testifying in this court, right here, right now. Any, out of court. He said, she said, even I said, fits this definition. Out of this court. So even an earlier statement made in court in a related proceeding is considered out of court for the definition. Yes. Statements made at a probable cause hearing in the very same case are out of court for this, other than while testifying right here, right now. That's the easy part of the rule if you think about it, right? Out of court. Because almost every other statement in the world is going to be other than while testifying right now. Any out of court statement. So what's a statement? He said, she said, I said, are statements. If you agree that those are all statements, nod your head like this. And that's a statement too, right? Well understood gestures as statements. Where's the clock? It's a statement. It's an out-of-court statement. Well understood gestures as statements. What aren't statements? What time did the clock say it was? Only people make statements, right? Things don't make statements. Clocks don't speak. Breathalyzers don't speak. Odometers don't speak. Tracking dogs, when they go in and go like this, they don't speak. Things don't speak. Only people make statements. Out-of-court statements. It's not just what I say. It's what I write. Her notes are hearsay. The book is hearsay. An affidavit signed under the penalties of perjury, put a nice blue ribbon on it, notarize it, still hearsay. Out of court statement. Anything other than while testifying right here, right now. Out of court statement. Offered to prove the truth of the matter asserted therein. Here's the tough one, right? Offered to prove the truth of the matter asserted therein. So what isn't it? Well, frequently misunderstood. It isn't, this is really relevant. I've got to get this in. That's not the definition of hearsay. That's the definition of relevance. Does it tend to make a proposition of a fact more or less likely? The more important it is, the more relevant it is. It has nothing to do necessarily with whether it's hearsay or not. Hearsay turns on whether it is offered to prove the truth of the matter asserted therein. If it is not, it's not hearsay. If it is, we got to go further. Doesn't make a difference how badly I need to get it in. That's relevance. Charlie asks a question. I say, Charlie, you are as dumb as a rock. You will get out now. As long as I'm dean, you'll never graduate from law school. A very sad, dejected Charlie leaves, never comes back, finds a future in the food service industry. And then one of you comes across him someday and says, Charlie, you never should have let him do what he did to you. I'm a lawyer now, you know. We can make this right. And so Charlie sues. So, you sue on behalf of Charlie. Who do you sue? Me and the law school. Oh, you're really learning your law, aren't you? Okay. Sure, when it comes to a third, you can do that math, can't you? Okay, you're going to sue me and the law school. And the statements, as I remember them, are, Charlie, you are as dumb as a rock. I think we said get out now. you'll never graduate law school as long as dean. Right? Those are the statements that we're working with. So you want to offer those statements, I assume. What are you suing me for? And the law school. What's your cause of action? Oh, you haven't done torch yet? you got anything? Joanne, you got something for me? Huh? Emotional distress, intentional infliction of emotional distress, defamation, okay. Breach of contract, okay. So we've got something that you're working with here. So you want to offer those statements, I assume. So who do you call? Anyone who heard it, I heard over here. Let's talk about that first. Anyone who heard it, right? What is the requirement of the reason you can call anyone who heard it? Witnesses have to have personal knowledge about what they're testifying about, right? And so when we decide that statements are going to be admissible or we attempt to offer them, you can offer them through anyone who heard it. And the reason is because they can perceive, understand, remember, and communicate, right? In order to be a competent witness, you got to PURC. P-U-R-C. Perceive, understand, remember, and communicate. So as long as someone who heard it can offer it, that's who we're going to call. So which one of you do they call? Any one of you. That's right, Harold. Any one of you. Because here's what we sometimes think. Well, we got to put Charlie on the stand because he heard it and it hurt him. No. Any one of you. Any one of you is a competent witness to offer the statement. Any one of you. All we need, and this is an important basic rule with respect to hearsay, 801 and its exceptions. Anyone who heard it can offer it. Because sometimes you think when we get to the unavailability, well, don't we need the person who said it? Nope. Anyone who heard it can offer it. What's the only hearsay exception that requires the declarant to be available, and therefore we do need that person in order to establish the foundation? Past recollection recorded. The only one. Everything else, anyone who heard it is going to be the appropriate vehicle. So we call Eric. He's up the front. He pays good attention. He's been taking notes. We call Eric. By the way, let's deal with best evidence quickly. These guys have tape recorders. She's got impeccable notes. Amy, memory, so-so. Is it a best evidence problem? What is the best evidence rule? Nice. Nice. When you're trying to prove the contents of a writing, recording, or other document, you must produce the original unless you can adequately explain why you can't. Are you trying to prove the contents of a writing, recording, or other document, or are you simply trying to prove what I said? You're trying to prove what I said. Just because it happens to be recorded on something or her notes, or that there's a better way of proving something, doesn't make it a best evidence problem. Best evidence problem is mechanical. Again, application of the law. Are you trying to prove the contents of a writing, recording, or other document? If you are, then produce the original, unless you can adequately explain why you can't. And then for the purposes of the bar exam, remember on the FRE, we have a very relaxed best evidence rule. Photocopies are as good as the original. There must be a genuine charge as to authenticity. And it must be an important matter. Don't make a best, they say, don't make a best evidence objection on a collateral issue. But we're going to call Amy. And Amy is still a legitimate witness to be able to offer this if she can perceive, understand, remember, and communicate. Amy, on Saturday, whatever the date is, what did you hear Professor Coyne say to Charlie? Any objection? Thank you. Objection what? Hearsay. Hearsay. Let's deal with hearsay. Hearsay. Any. Is it an out-of-court statement? We're dealing with the first one first. And listen, I put brackets around them. I have to. And I've done this a lot longer than you. I still have to, even today when I'm trying a case, or someone asks me a question, I've got to look at that. I have to actually look at it in brackets Because to do the second part of the test, that's what I need to understand. What is the statement that we're asking if it's offered to prove the truth of the matter asserted therein? I've got to look at the statement separately. I've got to look to see, well, what is the statement we're talking about and what is the truth of the matter asserted therein? It is an out-of-court statement, right? As Charlie's lawyer, through Amy, the witness, are you offering that statement to prove the truth of the matter asserted therein? We're not? So what are you offering it to show?
You said it. You said it.
So you're offering it to say, he said it. That's it. So it's not offered to prove the truth of... What is the truth of the matter asserted therein?
Charlie's a dumbass.
Charlie's as dumb as a rock. Are you... Unless he is, you wouldn't be offering it to show that, would you? I mean, you're not offering it to prove Charlie's as dumb as a rock. How relevant is it in order to win your case to get this in? A scale of 0 to 10. 9, 10, it's high, right? How important is it? Well, this forms your whole basis for why he left. Relevant? Yeah, super relevant in all likelihood. Important? Yeah, really cruel, horrible thing to say in front of a room full of people. Is it offered, though, to prove the truth of the matter asserted therein? The answer is no. Words of defamation, words of contract, they are what we call legally operative facts as well. Because they have independent legal significance, they are not considered hearsay. They are not considered to be out-of-court statements offered to prove the truth of the matter. This is not offered to prove the truth of the matter asserted therein, non-hearsay. Questions on that? I think it's as good an example as we get when we start to think about how important a piece of evidence is, but that's really not a question about, is it hearsay? That's a question about relevance. What this is, are you offering it to prove the truth of the matter asserted therein? Testimony is in. Now, part of my defense is Charlie should have a tougher skin than this for a lawyer, right? You're all going to get beat up from various times. I'm sure you have already in your 3 years here. It's not going to get better. There's still judges out there who are going to try and cower you and push you around. I think Charlie needed to toughen up a little bit and should have stuck around. Maybe he would have got lucky and got out. Who knows? So I think it's on him, not me, for him leaving and losing his law school career. What did you hear Professor Coyne say next? Amy.
Objection.
Objection. Hearsay. Is it? Out-of-court statement. It's that, right? Is it offered to prove the truth of the matter asserted therein? How about we skip to 3 and come back to 2, because 3 might be a better illustration, perhaps. I don't know. Let's see what you think. Let's skip to 3. You'll never graduate law school as long as I'm dean. Out-of-court statement, yes. Offered to prove the truth of the matter asserted therein. Let's take a vote. Yes. Yes, probably. Okay, I'll give you a little wimpy one. Yes, probably. I think that's right. He's got to justify why he walked away and never came back. Because part of my defense will be he should have been tougher than that. He should have finished. He might have gotten out. But what he's trying to say is, listen, there was no sense in staying here at that point. He said, and he meant it, you'll never graduate law school as long as I'm dean. What's the sense in spending another minute there at that point? Is he offering that to prove the truth of the matter asserted therein? I think so. Because the truth of the matter is, Charlie will never graduate law school as long as I'm dean. That's why he walked away. That's why he didn't finish law school. I think that is the truth of the matter asserted therein, and that's why he's offering it. It is different from 1. And 2 might be the middle ground. I don't know what you guys think on 2. I wasn't sure even as we did it. You like? I think 2 we could argue about to a greater extent, and we can if you want, but I don't think it advances the ball much. I think 2 is one of those where we could say, I actually do think it's offered to prove the truth of the matter. I think I would tip on that side, but I do not feel as strongly as I do with respect to 1 and 3 on 2. Your call. You got a question?
Well, yeah, I mean, if you're saying as the dean, get out now.
Yeah.
The student's not going to get out now.
Well, you'd be surprised. No, I'm with you. But you'd be okay. But I'm with you. And I do think that's why I think it's offered to prove the truth of the matter. Let's go further with this because there's still a lot more. But I think this gets us past offered to prove the truth of the matter. You guys getting hot in here? No? You all good? Because, okay. Feels warm to me, but I'm not staying here for another 2 hours. You are. There's a lot more to our definition. So we're okay on offered to prove the truth of the matter asserted therein. Okay, out of court statement offered to prove the truth of the matter asserted therein is hearsay unless it's a party's own statement offered against that party. And this is essential that you got to get down because there's a lot that springs from this as well. The rule is any party can offer the opposing party's statements. That's what it is. Except for a party's own statements offered against that party. If we, for this, especially for number 3, since it is hearsay, Charlie says, as to coin, that's a party's own statement, because you said you sued me. That's a party's own statement offered against a party. Any party can offer the opposing party's statements. Theory being they're in court, they can refute whether they said them, they can tell us what they meant, but they're admissible. Okay? I can't offer my own statements under that rule, but I can offer the opposing party's statements. A party can offer their own statements only under an exception. The opposing party has the right to, except for a party's own statement offered against that party. Okay? Or, so as to me it's admissible, as to law school, they didn't say it. Or it's an agent of a party's statement, and the agent is either authorized to speak, or the statement concerns something within the scope or course of that agent's duties made while so employed. As to the law school, is it either an agent who is authorized to speak or a statement concerning something within the scope or course of that agent's duties made while so employed? Right? They put me here, they have me teach. It happened during class. It's coming in against MSL as well, probably under both scenarios, I think, as the dean, but certainly under the second half of this, it's an agent statement who statement concerns something within the scope or course of his duties made while so employed. Now, here's a trick with this that you've got to be careful about. Do not, when the fact patent says, we tell our employees, listen, they told me never do this again. You did that 3 other times and those students all were very upset. Don't say that anymore. He wasn't authorized to speak. It's either or. Either authorized to speak or concerns something within the scope or course of that agent's duties made while so employed. So just because, and we always disavow the statements after the fact, that's what we do. We don't want to be liable. Just because they say he wasn't authorized to speak doesn't dispose of the issue. It's one or the other, okay? So we've got parties' own statements offered against a party. We have agents of a party statement. Co-conspirators statements, nothing more than agents, right? Co-conspirators, we make each other our agents. A co-conspirator statement that is made in the course of or in furtherance, and in furtherance of the conspiracy comes in against all members of the conspiracy. Co-conspirator statement made in the course of and in furtherance of the conspiracy comes in against all members of the conspiracy. Just like an agent statement. Those first parts of this, party, agent, co-conspirator, are baby steps. Easy. The next part is hard, under 801. Or it's a prior statement of a witness who testifies at trial. Or it's a prior statement of a witness who testifies at trial. And it's one of identification made after perceiving someone. If it's not a statement of ID of a witness testifying at trial, it can only fall into one of 2 other categories. Either it's going to be inconsistent with their testimony, the prior statement, or consistent. A prior inconsistent statement of a witness who testifies at trial is coming in. Period. Think about that. Witness has got up there, testified, promised to tell the truth. Looked like a little choir boy, looked right at the jury. Jury's sobbing, all this crap. And there's prior statements out there completely at odds with what this witness just said. Should the jury know that this is a story that's different from what they said earlier? Absolutely. And the rule says they will. A prior inconsistent statement of a witness who testifies at trial is coming in. Your only analysis is, what's it come in for? It comes in for impeachment only if the prior inconsistent statement wasn't under oath. It comes in for impeachment and substantive evidence to prove the truth of the earlier statement if the prior inconsistent statement was under oath. Not under oath, only for impeachment. Under oath, impeachment, and substantive evidence. So a prior grand jury testimony, since it's under oath in a proceeding, comes in for impeachment and substantive evidence. Prior out-of-court statement to the police or to a friend or whoever, only for impeachment purposes. Lastly, it's a prior consistent statement of the witness who testified. We don't need it, and you can't admit it unless there's been an express or implied charge of recent fabrication, contrivance, improper influence, or motive. Somehow the story they just told, this has to be developed on cross then, somehow the story they just told is of recent invention, recent fabrication. They've got a motive to lie. Under those circumstances, if that charge comes on cross, then the fact that they have always told this prior statement and they've been consistent about it, then at that point you can offer the prior consistent statement because it rebuts the express or implied charge of recent fabrication, contrivance, improper influence, or motive. Beyond that, it's inadmissible. So a prior consistent statement you should never see on a direct exam of the witness who made it, because the charge has to come on cross that it's of recent fabrication, contrivance, improper influence, or motive. On a prior statement of a witness who testifies at trial, we're still on 801. Statement of identification made after perceiving someone, admissible if they testify at trial. Prior inconsistent statement of a witness who testifies at trial comes in for substantive and impeachment purposes if the prior inconsistent statement was under oath, impeachment purposes only if it wasn't, and a prior consistent statement of a witness who testifies at trial only comes in to rebut the express or implied charge of recent fabrication, contrivance, improper influence, or motive. I promised, yes.
I was going to ask.
What's your name?
Zach.
Zach.
I was going to ask you, we were talking about under oath, inconsistent testimony under oath.
Yep.
You said at trial, but what about something like a deposition or something?
No, it's okay. What I'm saying, when I say a prior inconsistent statement of a witness who testifies at trial, once a witness has testified at trial, another way we impeach them, we talked about BCD. One of the most significant ways we impeach them is with their prior inconsistent statements. Regardless of where the prior inconsistent statement was made, it's coming in. Okay, so that part of the analysis is kind of easy. A prior inconsistent statement of a witness who testifies at trial is coming in, because logically it's highly relevant. Your only analysis, but they're going to ask you to make this distinction, is what's it come in for? Does it come in simply for impeachment to cast doubt, or can it come in to prove the truth of the earlier statement as well? If the prior inconsistent statement was not under oath, it only comes in for impeachment purposes. If the prior inconsistent statement was under oath in a proceeding, it comes in for substantive and impeachment purposes. So prior deposition, prior probable cause hearing, even prior grand jury, which isn't subject to cross, comes in for substantive and impeachment. The reason being, logically, it can be crossed here because the witness is on the stand. So all it has to be is a prior inconsistent statement under oath in a proceeding, and it comes in for substantive and impeachment purposes. But they're going to ask you and require you to make that distinction. But it's a pretty straightforward distinction once you get the entirety of the 801 definition down. But this is, again, why you've got to get the entirety of 801 down. It's not enough simply to rest after party's own statement offered against a party. You got to have agent of a party. You got to have and know, one, under what circumstances an agent statement is useful, what's a co-conspirator's statement, and what the prior statement of a witness is, and under what circumstances it comes in. ID, inconsistent and under oath, substantive and impeachment, inconsistent not under oath, only impeachment, or a prior consistent statement to rebut the express or implied charge of recent fabrication, contrivance, improper influence, and motive. Listen, there's no BS around this, okay? Many of you know because I required you to do it when we were together. You got to memorize this, and it's a lot to memorize, but you memorize the whole multiplication tables in the second or third grade. You can get this down. If you're wasting $1,000 to not have the entirety of this definition down cold, before taking this test. Because this is an area, unlike character, habit, impeachment, this is an area you can wall off. You can say, damn, I got this, I think. Because you apply it mechanically. The definitions are very mechanical. And you got to do all of 801 before you go looking for an exception. Something isn't an excited utterance if it's a prior inconsistent statement of a witness who testifies at trial that's under oath. Something isn't even hearsay if it's not offered for the truth. Something isn't hearsay if it's a party's own statement offered against a party or an agent statement. You're going to be wasting time on exceptions, and you're frankly going to be going to the wrong place, cheating yourself out of answers you should have. This is doable, and you should write it over and over and over again till you got it. That's the way to attack it. Yep?
Yeah, good question. When you hand out a servant statement, servant and agent.
Servant, agent, same thing.
Same thing.
Yep. Anything else on? Okay, now let's quickly hit our exceptions. If you've got all of that definition down, you say, nope, it's hearsay, doesn't fit into any of 801. Then you got to start looking at your exceptions, and as you know, there's a whole ton of exceptions that potentially apply. The first big area and the easiest area to look at are the unavailability exceptions. In order to use the unavailability exceptions, the declarant must be Debbie, D-E-B-I. You got to satisfy Debbie to use the unavailability exceptions. Dead, exercising a privilege, beyond the subpoena power, or incompetent. If the original declarant isn't one of those four things, you cannot use those exceptions. Dead, exercising a privilege, beyond the subpoena power, or incompetent. The declarant must be one of those things. Can't satisfy that, no soap. If the declarant, the original speaker, is in fact Debbie, then you got to know what your unavailability exceptions are, and they are the 2 Ds and 3 Fs. How do I remember that? If you got 2 Ds and 3 Fs, you will be unavailable for the purposes of taking the bar exam. 2 Ds, 3 Fs. Dying declaration, declaration against interest, former testimony, family history, forfeiture by flight of a witness, forfeiture by wrongdoing. The reason it is essential to know under what circumstances a witness is unavailable and what the exceptions are is that this is an area that will help you eliminate wrong choices on the bar exam. If we've got those within the universe of A, B, C, or D, and there's no showing that that declarant is, in fact, unavailable, they're the wrong answer. It's that simple. You eliminate them. Every time we eliminate a bad choice, a misstatement of the law, or a misstatement as applied to the facts, we're increasing our odds statistically of passing this test. This is the way in which you attack this test, is by eliminating to the point where you will be making better choices at the end. You do not just jump to one answer. You eliminate the wrong ones, and then look carefully at what you think is the best answer based on your knowledge of the law. Every time we eliminate a wrong choice, we increase our odds of passing this test. That's the way you attack it. Dying declaration, it's a homicide or a civil case. So you can't have a dying declaration in a charge of assault and battery with a deadly weapon. Can't. because the rule itself says homicide or civil case, statement made while the declarant believes the cause of believing their death is imminent, describing what they believe to be the circumstances or cause of their death. Declaration against interest. Against the person's penal or pecuniary interest at the time it was made. It's almost always going to be in the person's interest who's now offering it. That's why we offer evidence, right? We offer self-serving evidence that supports us. We offer prejudicial evidence against you. That's the process. We don't exclude evidence simply because it's prejudicial. We don't exclude evidence simply because it's self-serving. Declaration against interest are almost always, virtually always, in the person who wants the evidence received because it helps them. That doesn't negate that it's a declaration against interest. It must be against the declarant's interest at the time it was made. It's obviously in my interest to offer that evidence now, or I wouldn't be offering it. Declaration against your penal or pecuniary interest. You know, I owe Professor Malaguti $5,000, and I'm never going to pay the SOB. You know, I shot Charlie last night. Declaration against my pecuniary or penal interest at the time it was made. Former testimony had to be subject to cross-examination at the time it was given, either by you or someone in privity with you, because it'll never be crossed now. Right? Declarant's unavailable. In order to be former testimony, had to be subject to cross at the time it was given. So can grand jury testimony be former testimony? The answer is no, not subject to cross. Nice and easy. Family history, records of dates of birth and death and things like that. And lastly, forfeiture by wrongdoing. Forfeiture by flight. You've caused the loss of this witness's testimony. Usually it's coercion, money, some type of wrongdoing. Because you have forfeited your rights to object to the witness's earlier statements as hearsay. It's a penalty provision. Forfeiture by wrongdoing, forfeiture by flight. You've caused the loss of that witness. It has to be something in addition to the actual event as a general matter. Right? Just because you cripple them in the fight where they're unable to speak doesn't necessarily constitute forfeiture by wrongdoing. When you go visit them in the hospital bed and you say, if you are stupid enough to come to court, then I'll finish this job. That's forfeiture by wrongdoing. Okay? Something in addition to the actual event is usually what the court looks for. We already talked about the only here. Now, then we get all our 803 exceptions, and we'll talk about them next week as well. There's only one exception that requires the declarant to be available. That is past recollection recorded, because we have to lay the foundation for why it's past recollection recorded. So again, if we've got a fact patent where the declarant isn't available, shows clearly in the fact patent that they're dead or something, you can't have past recollection recorded in. You've got to have the witness on the stand in order to lay the foundation as to why it's admissible. It's the only hearsay exception of all that requires the declarant to be available. Apply that, and you'll get a question right as a result of it. Go ahead.
I have a question about dying declaration.
Yep.
So, the person has to reasonably believe that death is imminent.
Yep.
Let's say the person said a statement and really believed he's dying, but recovered in the hospital.
Yep.
Can you still use that?
Well, you tell me under what... hold on. You guys tell me under what circumstances. So he definitely believes he's dying. Right? We all have a friend who's sick. When they're sick, they really think they're dying, but they oftentimes don't. But they really believe they were dying. The statement was about the cause of what they believe their death to be. Under what circumstances could that dying declaration be used? You're going to prove you're not dumb as a rock?
As long as they're not Debbie. If they're Debbie, you can
they have to
use
be
the dying declaration.
They have to be Debbie.
No. I'm saying that he has to be Debbie in order to
okay.
dying declaration is
and
reasonably believe.
And the hospital probably not able to go to.
Okay, so it has to be Debbie, and I heard it over here. So has to be a civil case, right? Has to be a civil case, because if the person survives, it's obviously not a homicide case. The only other time then you could use the dying declaration would be if it's a civil case. Good. Okay. Okay.
So you can't use that in a robbery.
Can't use it on anything other than a homicide case. That's what the rule says. And what they'll do is it'll be an assault and battery with a deadly weapon, and the person could potentially be unavailable if you think about it. So, you cripple them, you render them, so you satisfy Debbie. The rule specifically says homicide or civil case. So I would expect, if it were me, I would give you an A and B with a deadly weapon, a really brutal, vicious beating, such to render the person incompetent to testify. Just begs for you to say, you got to allow it in. Nope. Because it's a simple distinction. Homicide or civil case. That's what the rule says. Who was back here first? I'll come up, Zach. Susan?
The I and Debbie, infancy, is that 18 and under?
No. No. I is not infancy. I is incompetency. Incompetency is determined by your abilities. And by the way, incompetency, it makes it easy to have a nice mnemonic, but incompetency, you could also think a failure of memory could be so significant that you could determine them unable to testify. But with respect to age, when we talk about infancy, perception, understanding, recollection, and communication is the determination for being a competent witness. There is no set age where that happens. I always use the illustration. We had a case in Wakefield where the child who saw his aunt killed was 2 years old and 9 months at the time he observed his aunt killed, 7 years old when the case came to trial in Middlesex Superior. So which age do we use to determine competency? We don't use an age at all. We use perception, understanding, recollection, and communication. For some, that'll happen relatively early on, and at some, that's going to be foreclosed at some point in time. You also, all of you, I would assume, being where you are right now, are competent. Could you go across the street, ingest far too much alcohol to be a competent witness to testify about the events on the night in question? The answer is undoubtedly yes. So competency isn't determined by age, it's determined by you and the circumstances under which we're asking you to have the ability to perceive, understand, remember, and communicate. Okay? Let's just do Crawford just quickly, and I got to give you the test. I got to give you a couple quizzes. So we've gone through, we've found a hearsay exception. Your problem is your analysis isn't over, so make sure you pick up the Crawford handout so we can talk about it. But in a criminal case, even if you've found a hearsay exception, it doesn't apply to civil. Crawford and the Sixth Amendment apply only in criminal settings. Even if you've found an exception to the hearsay rule, if this is what the courts have called testimonial hearsay, what I call an accusatory statement to or from a law enforcement official, if that's how the statement came about, the out-of-court statement, then the Sixth Amendment, Crawford, Melendez-Diaz, says that witness has to be available for cross-examination in order to allow that testimony in. So your analysis in a criminal case isn't over when you found an exception. You have to say, is this an accusatory statement to or from a law enforcement official? If it is the witness available to testify? Because only if they are can you then use that to come in. So whether it's a drug certificate or whether it's a statement given to a police officer who comes to the house at the time about the beating you suffered, that's an accusatory statement to or from a law enforcement official. The witness has to be available to testify in order to satisfy Sixth Amendment, Crawford, Melendez-Diaz. We'll talk about that some more after you've looked at the handout. But it's something you should be aware of and applying, because in a criminal case, we've got an additional hurdle once we've gone through our hearsay analysis. Okay? Put your stuff away. I'll give you we got a quiz, 2 quizzes to do.